Hello, I'm Becky, and I'm here on The Law is My Oyster to tell you about the orders you can ask a judge to give you in terms of Ireland's Domestic Violence Act of 2018. Please note, this is not meant as legal advice. It is information for students, but if you are in a dangerous situation, it will hopefully help speed things along when you consult with your lawyer for the first time. Your lawyer's advice will be dependent on your particular circumstances, and it is impossible to cover all eventualities here. Please speak to your lawyer. First, I will tell you about the full orders. These are the safety order, the barring order, and the emergency barring order. Then I will tell you about the interim orders, which are there to protect you while you wait for your court hearing date. These are the protection order and the interim barring order. Let's talk about the safety order first. This is governed by Section 6 of the 2018 Act. What is important to remember about the safety order is that it does not throw the abuser out of the residence if you are living together. If you are not living together, the safety order can prohibit the abuser from coming closer than a certain distance, for example, 500 meters. This is often called a stalking order. You can ask the judge to make exceptions to this stalking order, for example if kids need to be picked up or dropped off, or if you both need to attend a parent-teacher meeting or some other school function or sport meeting. It is a good idea to ask for these things at the same time that you apply for the safety order, as it will save you having to return later when you realise you have made no practical arrangements regarding the children, for example. It is important to remember that you must qualify as an applicant before you can apply for an order against a respondent, your abuser. You can watch an earlier video titled the Locus Standi here if you want, but I will explain this requirement briefly here. Where the abuser is your spouse or civil partner or the parent of your child, you would need to produce the documentation to prove that in order to qualify as an applicant. If your abuser is neither your spouse nor civil partner, you would need to prove that you were in an intimate relationship with the abuser before coming to court. Although this is still not absolutely certain, Irish law seems to recognise that a relationship does not stop being intimate when the sex stops, but this does imply that there was sex at some stage in the relationship, and that the applicant and respondent were a couple. Where a parent applies for an order against their adult child, over 18, they would need to show that their adult child is not dependent on them, more specifically, could live without them. Finally, people who are in a business together or who are joined by a business contract of some sort do not qualify to ask for an order against the other person. However, for example, a person could apply for an order against an adult sibling under this category. The 6 categories of applicant for the safety order are the most categories for any of the orders, which is why the safety order is so popular. The other reason, as mentioned before, is that the abuser is not thrown out of the shared residence, and so the courts are not as strict when granting the safety order as they would be with a barring order. A safety order can last for up to 5 years, in theory at least. But it would be unusual for a court to grant a safety order for its maximum duration. Next up is the oldest and most serious order, the barring order. This is governed by Section 7 of the 2018 Act. So the important thing to know here is that the abuser is thrown out of the shared residence. This has all sorts of legal implications, and so it is that more difficult to get a barring order. Who can apply for a barring order? The first thing to notice is that the number of eligible categories has gone down to 4 types of applicant. Apart from that, they are the same as the first 4 categories in the safety order, and therefore the same requirements apply before you can qualify as an applicant for a barring order. The big thing here is that your evidence will need to be stronger, and it needs to show that the abuser was guilty of serious misconduct which harmed your safety or welfare, which pretty much covers all the different forms of domestic abuse that you have read about. For example, proof of your physical injuries might be date-stamped photos, medical records, neighbours' testimony, etc. After listening to you describe your particular circumstances, your lawyer will explain to you the type of evidence that you will need when you go to court. The other big thing is what is known as interest. The section speaks of legal interest and beneficial interest. These concepts are not defined, and to explain them is like trying to hold a slippery fish, as they are so dependent on your particular circumstances. Let's just say for now that legal interest often consists of things that you can put a price on, a euro value, whereas beneficial interest is more about who will suffer the most if the order is or is not given. Importantly, interest is not the same as ownership. You can have interest in a residence even though you do not own it. For example, if you contribute to the mortgage or the electricity account or pay to have the roof repaired. Your money has gone into the shared residence, and therefore you have a legal interest in the residence. But, and this is a big but, you must have more interest in the shared residence than the respondent in order to have a chance at getting this order. Again, your lawyer will meet to guide you through that and again explain the sort of evidence you will need to bring in order to prove your interest in the shared residence. An initial barring order can be granted for up to 3 years. But again, it would be quite rare for a court to grant the full term. Next up is the newest kid on the block, the Emergency Barring Order, which was created by the 2018 Act. This is governed by Section 9 of the 2018 Act. As it is also a barring order, the abuser is thrown out of the shared residence. Unlike the previous barring order, it is given on the basis of an emergency, and so it is a little easier to guess, but it does not last for long. The emergency barring order was created specifically for those applicants who have no interest in the shared residence, or who have less interest than the respondent in the shared residence. Do you remember when we talked about interest? The legal and beneficial interest that you have to prove for a barring order? Well, for an emergency barring order, you do not have to prove interest at all. For this reason as well, there are only 2 categories of applicant, the 3rd and 4th categories in the other orders, the couple in an intimate relationship, and the parent against adult child category. The same internal requirements apply to these categories again, so have a look at the previous discussion to remind yourself. The other thing about the emergency barring order is that you can ask the court in secret. You do not need to tell your abuser that you are going to court to get an order against them. This is known as an ex parte application. You do not tell your abuser that you are going to court, and the first time they know about it is when they get the order telling them to get out. Just remember that if you do tell your abuser that you are going to court, and they do not attend, this is known as a default hearing, which is different from an ex parte hearing even though the result is the same. You are there on your own without your abuser being in court. The emergency barring order is not the only order that allows a secret application. You can ask for some of the other orders on an ex parte application as well if you can show that it would be dangerous for your abuser to know about the court application beforehand. Ask your lawyer about this. The downside of the emergency barring order is that it lasts for a maximum of only 8 days, and you can only ask for 1 per month. This is, firstly, because it can be applied for in secret, but perhaps more importantly, because there is no interest requirement. This is really for people who have no expectation to remain in the shared residence. What it does give you is safe passage to get your things and get out and away. Because these applications for full orders require evidence and perhaps witnesses and maybe some legal argument, they have to be given a court date in advance. As the courts are very busy, you might have to wait for some time before your court hearing comes up. This can be a dangerous period, as we know that the level of violence and intimidation often increases when the abuser hears they are going to court. That is where the interim orders come in. Interim simply means the in-between, and that is what these orders do. They protect you for that time period in between the date you made the application for the full order and the date of the court hearing of that application. The protection order is really an interim safety order, but it is not called that because you can apply for it after you have applied for a safety order or a barring order. The interim barring order is exactly what it says on the tin. It is an order that you can apply for after applying for a full barring order. These orders have similar requirements to their full counterparts, so, again, speak to your lawyer. I hope this video has been of some help to you. Remember that Women's Aid is always there for a sympathetic ear, a helping hand, and useful advice.